everyone, welcome to our channel Knowledge Hub. Friends, subscribe to our channel and click the bell icon for the latest update. This is your class Sociology that we'll discuss today here itself, and that is your class 5. As I told you about that, we had done with class 4, and where we had discussed unit 1, unit 2, unit 3, unit that I will start with unit 4 here as well. And the name of the unit that we have is your contemporary issues, and that we'll discuss here. In contemporary issues, first we'll talk about some of the topics. Before starting with that, it's a huge request from my side to all the viewers, please go through with the subscribe button and please like, share and subscribe our channel, so that many and maximum people can get the information at once, and even though you can also enjoy the video as well. We'll go ahead and further we'll discuss about it. And in the same cases, here this is your unit 4, which is your contemporary issues. Here in this we'll discuss about introduction and definitions of grievances, and in the same cases that what is grievances. So what is grievances and what are the causes of grievances? This has been asked in the examination paper of 5 marks, so we'll discuss about the introduction and the definition of grievances as well. In this, that is, grievances is any dissatisfactions or feeling of injustice having connection with one's employment situation, which is brought to the attention of management. Speaking broadly, grievances is any dissatisfaction that adversely affect organizational relation and productivity. To understand what a grievances is, and it is necessary to distinguish between dissatisfaction, complaints and grievances as well. Dissatisfaction is anything that disturbs an employee, whether that or not the unrest is expressed in words as well. Complaint is that it is a spoken or written dissatisfaction brought to the attentions of the supervisor or the shop steward. Grievances is a complaint that has been formally presented to a management representative or to the union officials as well. Where in the same case, according to the Michael Jusius, grievances is any discontent or dissatisfaction, whether expressed or not, whether valid or not, arising or not, and anything that is connected with the company which an employee thinks, believes, or even felt in unfair, unjust, and inequitable here. That in a short, grievances is a state of dissatisfaction, expressed or unexpressed, written or unwritten, justified or unjustified, that having the connection with employment situation as well. We'll discuss about the definitions of employee grievances here. In the same cases here, that the employee grievances refers to the dissatisfactions of an employee with what he expects from the company and its management. A company has to provide an employee with a safe working environment, a realistic jobs preview, and adequate compensation, respect, etc. In the same case, the grievances may be any genuine or imaginary feeling of dissatisfactions or justice which an employee experiences about his job and its nature, about the management policy and procedures. It must be expressed by the employee and brought to the notice to the management and organization. Grievances that take the form of the collective disputes when they are not resolved, and also they will then lower the morale and efficiency of the employee. Unattended grievances results in that is your frustration, dissatisfaction, low productivity, lack of interest in work, and abstention as well. In the same cases, where we'll talk about the causes of grievances. In the causes of grievances here, that the grievances is feeling of unfair treatment at work. It can be resulted from dissatisfactions of work. In this regard, the sources and the causes of the grievances that can be anything that result dissatisfactions or involving wages, working hour, or conditions of employee that are basis of grievances. The causes of the sources of grievances are classified into 3 categories that are as follows. The first, we have management policies. The second, working condition. The third, interpersonal factor. In management policy, the policies are procedures adopted by a management that give rise to the grievances and the autocratic and a bureaucratic style of management, for instance, is hardly liked by educated masses, but they favor rather a participative style of management. And similarly, management practices also led to an employee grievances at work as the want to exploit employees through reductions in pays and other benefits. Grievances resulting from management policies are, that is, the salaries, overtime, leave policies, lack of growth in career, conflicts in the roles, unmatched skills and responsibility, disciplinary actions, and in the talking about the working conditions are relative in the work environment of the organization. If the working environment of a company is good, employer will get place for grievances. Grievances resulting from working conditions that are as to be follows, like unhygienic work environment. The second we have is your, that is, safety issues, insufficient equipment, indiscipline and wrong approach to discipline, and of course the unrealistic expectation and transfer as well. Talking about the interpersonal, that factor where the personal factor are related to the personality traits of individuals. Sometimes these personality traits also cause the emergence of grievance at work. Some important personality traits that results into grievances are like inability to get along with superior, poor relation with team members, ego, and impractical approach to life as well. Now we will go ahead with other question that what we have to talk about it, which is what is grievances, and give a formal grievance procedures to handle it. This has been asked in 6 times in the examination paper of 6 marks as well, where we talk about it in detail, where that is your grievances. About grievances, in grievances, a grievances is any dissatisfaction or feeling of injustice having connection with one's employment situation which is brought to its attentions of management. Speaking broadly, a grievances is a dissatisfaction that adversely affect organizational relation and productivity. Where grievances handling procedures, talking about grievances procedure is a formal communication between an employee and the management designed for the settlement of grievances. The grievances procedure differ from organization to organization, where in the same case, the first we have open door policy. In an open door policy, under this policy, the aggregate employee is free to meet the top executive of the organization and get his grievances redressed. Such a policy works well only in a small organization. However, in a big organization, a top management executive are usually busy with other concerned matter of the company. Moreover, it is believed that open door policy is suitable for executives and operational employee that may feel shy to go to the top management as well. The second is your step ladder policy. In this, under this policy, the aggrieved employee has to follow a step-by-step procedure for getting his grievances redressed. In this procedure, whenever an employee is confronted with a grievances, he presents his problem to his immediate supervisor. If the employee is not satisfied with the superior decision, then he discusses his grievances with the departmental head, and the departmental head discusses the problem with the joint grievances committee to find a solution. And however, if the committee also fails to redress the grievances, then it may refer to chief executive, and if the chief executive also fails to redress the grievances, then such grievances is refers to as voluntary arbitration, and when the award of arbitration is binding, then on both the parties as well. I will talk about the grievances procedures in Indian industry, and that is that the 15th sessions of Indian Labour Conference held in 1957, that is held in 1957, and that emphasized the need of the established that is the grievances procedure for the country, which would be acceptable to the union as well as the management. In 16th sessions of Indian Labour Conference, a model for the grievances procedures was drawn up, and this model helps in creations of grievances machinery. According to it, the workers' representatives are to be elected for the departmental as their union is to be nominate them, the management, and to specify the persons in each department who are to be approached first, and the departmental heads who are supposed to be approached in the second step as well. Where in the same case we can say that The model grievances procedure specifies the detail of all the steps that are to be followed while redressing grievances, and these steps are: in the first step, that the grievances is to be submitted to a departmental representative who is representative of management, and he has to give his answer within 48 hours as well. In the second step here, that is, if the departmental representative fails to provide the solution, the aggrieved employee that can take his grievances to head of department, who has to give the decision within 3 days. In step 3, that is, if the aggrieved employee is not satisfied with the decision of the departmental head, he can take the grievances to grievances committee. The grievances committee make its recommendations to the management within 7 days in the form of the report. The final decision of the management on the report of grievances committee that must be communicated to aggregate employee within the 3 days of the receipt of the report. An appeal for the revisions of final decision that can be made by the workers, that if he is not satisfied with it, and the management must communicate a decision to the workers within 7 days as well. We are in step 4, that is, if the grievances still remains unsettled, the case may be referred to voluntary arbitration. That here we have, this is your aggrieved that employee, and that comes towards the departmental representative, then head of the department, then the grievances committee, and then we have a chief executives, and of course the voluntary arbitration. For this is the settlements of grievances, and for the departmental representative, they have to answer within 48 hours. The head of the department have to give the answers, that is within 3 days, and for the grievances committee, they have to answer 7 days, and chief executive, they have to answer within 7 days here. So these were the process in terms of it. Under the normal circumstances, that the time frame referred to the hearing, hearing should be followed, and any change in these time frame that must be authorized by the employee relation officer in that consultations with involved parties, and these time frames, unless otherwise specified, and do not include the days when the college is not open for normal operations, or days when either the grievant or respondent are unavailable due to the illness or previously scheduled time away as well. Now we'll discuss about what is grievances committee, which has been asked of 3 marks, as you can see here. In the grievances committee, about this, that is, a grievances committee is a group of people assigned to address a complaint or a problems, and a group of representatives chosen from a labor union or from both labor and management to consider the remedy workers' grievances. And the grievances redressed committee shall consist of equal numbers of persons from both sides, and fixes a 30-day time limit for grievances handling. An example of the grievances committee is a team of employees that's set up to deal with customer complaint. Now we'll talk about the procedures, periodicity, and attendance at a meeting as well. In this, that we'll talk about here one by one. That is, the grievances committee will meet at least once a month, and however, if necessary, it may be meet more frequently at an instance of the convener or of the request of the other members to discuss the various issues received. At least that 3 members of the grievances committee shall be presented in a meeting. If the number of the grievances committee is connected with the grievances of the aggrieved individual, the concerned members of the grievances committee shall not participate in the deliberation regarding the individual's cases as well. In the same case, if the aggrieved person happens to be a member of grievances committee, then he shall not participate in the deliberations as the members of committee when his or her representation is being considered as well. We'll talk about another one, which is what is the role of works committee in grievances handling procedure. So the role of the work committee in the grievances handling procedure, which is your work committee. In terms of it, that what we have to talk about it here. That the government has incorporated the various provisions under the Industrial Disputes Act 1947 and preventing the dispute. The main purpose of the measures is to prevent the dispute before they arise, and machinery for the settlement of dispute if the dispute could not prevail on voluntary basis and do arise. The Industrial Disputes Act 1947 provides here that the several provisions for the setting disputes. Such provisions is of that the work committee as well. In terms of work committee, if I'm talking about here, as you can see, so in the work committee there is a works committee in a fractions that is employing 100 or more workers, which is section 3 here, and that has been named. So the committee will come of equal number of representative of employer, and an employer representative of employees will be selected in consultation with the registered trade union. The works committee will first try to settle disputes before any other action as well. We'll talk about the industrial disputes, that is the another one, and the industrial disputes, as well as in same cases the question has been asked, define industrial relation and industrial disputes or industrial conflict. That has been asked of 3 times in the examination paper of 5 marks, and they can ask you what are industrial relation directly. So we'll discuss about the concept of industrial relation, that we have to go ahead. So that the concept of industrial relation here in this that we have to talk it where that the concept of the industrial relation has been defined that using of various terminologies, but in the strictly sense it is essentially the relationship between the management and that the labor. That the full concept of industrial relation is the organization and practice of multi-prolonged relationship between the labor and management union and a labor union and management in an industry. The Dale Yoder that defines the whole field of relationship that exists because the necessary collaborations of men and women in the employment process of the industry has been taking place here. So according to the Dale Yoder, that the concept is used to denote here that is the collective relationship between the management and the workers, and this is also called by the labor relation, and that is the term of the industrial relation comprises by the 2 terms industry and relation. So industry refers to any productive activity in which individual or a group of individuals is or are engaged, and industrial relationship refers to the relationship that exists with the industry between the employer and his workmen or employee, and that is the relation also defined that the way in which the 2 or more people or a group of feel about the behavior that towards each other, and the way in which the 2 or more people or they are connected. A thing affect or the relevance to the another, and industry relation contain the relationship between employee and employer, as here as you can see here as well, and that is this is also including the other third party stakeholder who are influenced in to this work management relationship, and such a government of governing bodies as well. If I'm talking about according to the Dale Yoder, that is the industrial relation is a designation of a whole field of relationship that exists because of the necessary collaborations of men and women in the employment process of industry as well. We are in the same case according to the Armstrong here. In the Armstrong here, that is the industrial relation is concerned with the systems and procedure used by a union and employers to determine the reward and the effort and the other conditions of employment, to protect the interest of the employed and their employers, and to regulate the way in which the employer treat their employment as well. And in an opinion of B.B. Singh here, that the industrial relations are an integral aspects of social relation arising out the employers and employee interactions in a modern industry, which are regulated by the state in varying degree in conjunctions with organized social forces and influenced by the existing institution. This involves the study of state, that the legal system, and the workers and employers organizations at the institution level, and of the pattern of industrial organization, which including the management, capital structure, including technology, compensation of the labor forces, and the study of the market forces, all at economic level. We'll talk about the Encyclopedia that Britannica, that define the industrial relations more elaborately, as the concept of industrial relation has been extended to denote the relation of the state with employers, workers, and the other organization. The subject that to include individual relation and joint consultation between the employers and workers at their places of work, collective relation between employers and a trade union, and the part that played by the state in regulating these relations as well. Where in the same case we'll talk about here, that is the concept of industrial disputes, as you can see here. In this, in a common parlance dispute, that means difference or disagreement of the strife over some issues between the parties, and as regards industrial disputes, since its settlement proceeds as per the legal provision that contained in the Industrial Dispute Act 1947, and hence it seems that you are pertinent to study the concept of industrial disputes from the legalistic angle as well. As per the section 2J of Industrial Dispute Act 1947, industry means any systematic activity that carried on by cooperation between an employer and his workmen, whether such workmen are employed by such employer directly or through any agency, including a contractor, for the production, supply of distribution of goods or services with view to satisfy the human wants or wishes, not being wants or wishes that which are merely spiritual or religious in nature, whether or not as well. In the same case, any capital has been invested for the purpose of carrying on such activity, or such activity is carried on with motive to make any gain or a profit, and includes any activity of the dock labor board established under the section 5A of the Dock Worker Regulations of Employment Act 1948, 9 of that is 1948 as well. Any activity that are relating to the promotions of sales and business, or both are carried on by an establishment. We will talk about it, that is definition of industrial dispute, as you can see here. So definition of that is your industrial disputes here, as per the section 2K of ID Act 1947, which is Industrial Dispute Act 1947. Industrial dispute means any dispute or a differences between employers and employers, between employees and workmen, and between workmen and workmen, so which is connected with the employment or non-employment, or the terms of employment, or with the conditions of the labor of any person. Disputes differ from the disciplines and grievances. While disciplines and grievances focuses on individual, disputes focus on collectively of individuals, and in another word, the test of industrial dispute is that the interest of all or majority of workmen is involved in it. We'll go ahead with other question that we have to talk about it. We are in the same cases, which is your that is in the same case that define industrial disputes, and what were the various causes of industrial disputes in India. So that we had discussed about it, and that has been asked 8 times in the examination paper of 5 marks. So this is very important question as well. According to the section 2 of the Industrial Dispute Act 1947, industrial disputes means any disputes or differences between the employers, or between employees and between workmen and workmen, which is connected with the employment or the non-employment, or the term of the employment, or with the conditions of the labor of any person. Industrial disputes are of the symptoms of industrial unrest, in the same way the void and symptoms of the disordered body. Whenever an industrial disputes occur, both management and worker try to pressurize each other, as well as the management may resort to lockout, and the workers may that resort to strike and gherav, and that picketing, etc. We'll talk about the causes of industrial disputes here. We can classify that the cause of the industrial disputes into the 2 broad groups, which is we have economic cause and non-economic cause. In economic cause, that the wages, bonus, dearness allowances, conditions of work and employment, working hour, leave and holiday with pay, and unjust dismissable that is a retrenchment as well. Non-economic causes as well, that is your recognitions of trade union, victimizations of worker, ill treatment by the supervisory staff, sympathetic strike, and political cause, etc. That comes under the non-economic causes that we include here. Now we'll discuss the preventive machineries industrial disputes. That the question has been asked is what are the tripartite and bipartite machinery, that what is difference between the two bodies as well, and other than that we have to explain the role of the government machinery to resolve the industrial disputes as well as what is the role of the work committee in grievances handling procedure as well. So here we go ahead, and that the another question that they can ask you about it, and which is in the same cases, that is about to describe the conciliation, that is your arbitration and adjudications process in industrial relation, which has been asked of 6 times in the examination paper of 6 marks. And write a note of workers' participation in management, which has been asked of 3.5 marks, and state the provisions relating to the three-tier system of the adjudications under the Industrial Disputed Acts 1947, that has been asked for 5 marks. Now we'll discuss about it, and that is the industrial disputes, the settlement machinery for India. Here the first we have for this. So here the first we have is your machinery for preventions of industrial disputes. In this, that is after the independence, the government of India passed the Industrial Disputes Act 1947, under which the machinery for the preventions and the settlements and dispute has been outlined, and the provisions are as to be taken as under. In the same cases, that is your that we'll talk about it as that machinery for the prevention that industrial disputes. In this, that the preventions and better than cure. So the government has incorporated in the act for preventing the disputes, and the main purpose of the such measures is to prevent the dispute before they arise. The other we'll talk about is that is your machinery for the settlement of industrial disputes. In this, if the disputes could not be prevented on a voluntary basis and do arise, and the Industrial Disputes Act 1947 provides several provisions for settling the disputes. Such provisions are, that is your that we talk about work committee, conciliations, and then we have a sub parts of that related to as well. So that we will discuss here itself. So about the work committee here, that is that there is a works committee in a factory employs 100 or more workers, section 3, and that the committee will consist of equal numbers of representative of employer and employees, and representative of employers will be selected in consultation with the registered trade union, and the worker committee will first try to settle disputes as well. This has been asked, and that is your the next we'll talk about the conciliation as well and the parts as well. So in work committee, as what we have to talk about it as this is, as I told you, about the selected consultation registration trade union, and the work committee will first try to setting disputes as well. We'll talk about the second one, which is your that is your conciliation. In conciliations here, if I'm talking about conciliation, that the conciliation refers to the process by which the representatives of the employer and employers are brought together before the third party with the view of to discuss, that reconcile their differences and to arrive the agreement through the mutual consent, and the third party act as facilitated in the process. Conciliation is a type of a state interventions in setting up the industrial disputes, and the Industrial Disputes Acts empower the central and a state government to appoint these conciliations officers and a board conciliation as when the situations demands here. In that we have a subcategorizations that we have. The first subcategorization is for the 2A, that we can say that conciliations officer. In conciliations officer, here in this, that the appointment of the conciliations officers is made by the state government for the particular region or industries in a state, and the main duty of these officers is to bring the two parties together and help them resolve their differences, and they can do everything to settle the disputes between the two parties that is amicably, and it is bound to make a decision within 14 days or such period as extended by the state government from the date of the registrations of dispute. If the dispute is settled through his good offers and agreement is reached, he should send a report to the government along with the memorandum of settlement and signed by the parties of the disputes, and in the case the dispute is not settled, then that should inform the government about his failure and step taken and reasons for not being successful as well. With the same case, the B we have is your conciliation board. Second B is your conciliation board. In conciliation board, here in the case of the conciliations officers that fails to resolve the disputes, the government appoints a board of conciliations on an hoc basis for the particular dispute, consisting of a chairman and a 2 or a 4 person representing the employer and the employees, to bring the parties to disputes to sit together and thrash out their differences as referred to by the government, and the board reports the government about the success of the failure to bring about the settlement within the 2 months from the date of the references of the disputes as well. Where the board of the conciliation consists of the chairman, who must be an independent person, and 3/4 member that is 3/4 members in unsolved matters that may be referred to a labor tribunal, industrial tribunal, and the labor court, which is section 12(5) as well. The third we talk about it, as I told you, first is your work committee, second is your conciliation, and the third we have is your court of inquiry. Court of inquiry. In court of inquiry, here in this, that whenever an industrial dispute remains unresolved by the conciliations officers and the board of conciliation, the matter is referred to the court of inquiry, and the court may consist of one more independent person. It will investigate the whole disputes and submits its report to the government on the matters refers to it ordinary within 6 months from the date of the commencement of inquiry as well. The fourth we have is your adjudications as well. In the adjudication that we talk about it, which we have, the fourth is adjudication. In adjudications here, that the adjudication is an ultimate legal remedy for the settlement of industrial disputes. Adjudication means that the interventions of legal authority appointed by the government to make the settlement, which is to be binding on both the parties. In other words, the adjudication means a mandatory settlement of the industrial dispute by the labor court or the tribunal. For the purpose of adjudication, the Industrial Dispute Act provides a 3-tier machinery. The first we have is your labor court, that is labor court. The second we have here is your industrial tribunal. And the third we have is your the national tribunal. In this we'll talk about in detail But the labor code here, that is that to be as follows. Where in before that, if the settlement is not arrived at, that the efforts of the above machinery, a three-tier machineries for the compulsory adjudication is provided under the act, and these are the three types of the semi-judicial bodies, that is labor courts and industrial tribunals and the national tribunals as well. So we'll talk about the labor code here, that is that the appropriate government may be by notification in the official gazette constitutes one or more labor code for the adjudicating the industrial disputes relating to any matter specified in the second schedules of the Industrial Dispute Act. They are that the dismissal of the discharge or the grant of relief to the workman wrongfully dismissed, and that is the illegality that or the otherwise of the strike or the lockout, withdraw of any customary concessions or the privileges, and where an industrial dispute has been referred to a labor court for the adjudication, it shall hold it proceeding expeditiously and shall within the period specified in the order referring such the dispute and submit its report to the appropriate government as well. In industrial tribunal here, that the appropriate government that may be by notification in the official gazette constitutes one or more industrial tribunal for the adjudications of the industrial disputes relating to the following matter, which is your wages, compensatory and other allowances, hours of work and rest intervals, leaves with wages and holidays, bonus, profit sharing and PFs, etc., rule of disciplines, retrenchment of workmen and working shifts other than in accordance with the standing up orders as well. It is the duty of the industrial tribunal to held in proceeding expeditiously and to submit its report to an appropriate government within the specified time. In the national tribunals here, that the central government that may by the notification in the official gazette that constitutes one or more national tribunal for the adjudications of industrial disputes and matter of national importance as well. The matters which are of nature such that industries in more than one state are likely to be interested in and are of affected by the outcome of the dispute as well. It is the duty of the National Tribunal to hold its proceeding, that is, your expeditiously, and to submit its report to the central government within the stipulated time as well. I'll talk about the next one, which is the fifth one, that is your arbitration here. So the fifth one we have is your, that is arbitration. In arbitration here, in this, that is a process in which a neutral third party listens to the disputing parties, gather information about the disputes, and then take a decision which is binding on both the parties. In the court, that conciliators simply assess the parties to come to the settlement, where the arbitrators listens to the both the parties and then gives his judgment. And there are two types of arbitrations as well, where the first we have is your voluntary arbitration. So in voluntary arbitration here, that is in voluntary arbitration, that the arbitrators is appointed by the both the parties through mutual consents, and arbitrators that acts only when the disputes is referred to him as well, and in that is to him. And the second is your, that is your the compulsory arbitrations here. The B is compulsory arbitration. In this, that implies that the parties are required to refer to the dispute to the arbitrators whether they like him or not, and usually when the parties fails to arrive the settlement voluntarily, or when there is some other strong reason, the appropriate government can force the parties to refer the disputes to any arbitrator as well. In the same cases, we'll go ahead. That is the another question. What is a strike? Explain various types of strikes and their reasons. This has been asked of 6 marks. And the other question that can ask me, that is your, is what is a strike? So we'll go ahead here and to discuss about the strikes here. So in terms of strike, that strike means that any temporary stoppage of work by concerned actions of the employee as a result of industrial or labor disputes. Strike is a very powerful weapon used by trade union and the other labor association to get their demands accepted, and it is generally involve a quitting of work by a group of workers for the purpose of bringing the pressures on their employer so that their demands get accepted. And when workers collectively cease to work in a particular industry, they are said to be on strike here. And that is in the same cases that the strike action, also called a labor strike and a strike grieve and or simply strike, is a work stoppage caused by the mass refusal of employ a work and employees as a work in that strike usually takes place in response to employ the grievances strike that became important during the industrial revolution. And when that is your when many laborers become important in a factory and mines, and in the most countries the quickly made illegal as factory owners had far more political power than workers. So most western countries partially legalized striking in the late 19th and the early 20th century as well. We'll talk about the causes of strike here, that we have to talk about it, and which is in the same cases. The causes of strike. In the terms of causes of strike here, that is the strikes can occur because of the following reason. The first we have is your dissatisfactions with the company that policy, salary and incentive problems, wrongful disciplines or the dismissals of workmen. These were the causes of strike. The withdrawal of any concessions that or privilege, hours of work and rest intervals, dispute connected with minimum wages as well. We'll talk about the types of strikes as well. That is also an important one. And the types of strikes we'll discuss here as well. Types of strikes. In terms of types of strikes that we talk about it, and in that the causes of strike we had discussed about it, the strike we had discussed about it, and now we'll go ahead with the discussion about the types of strike. So how many types of strikes there are, and that what we are dealing with in terms of the strike as well. So the first type of a strike we'll talk about more than seven strikes here as well. The first strike is your economic strike. In economic strike, that under this type of a strike that laborers stop the work to enforce their economic demand such as wages and bonus. And in this kind of a strike that workers asked to increase the wages, allowances like traveling allowances, house rent allowances, dearness allowances, bonus and other facilities such as increase in privilege leave and that is your casual leave as well. The second strike is your the sympathetic strike. In sympathetic strike, if I'm talking about in this, that the when workers of one unit or industry that give on strike in sympathy with workers of another unit or industry who are already on strike, it is called a sympathetic strike, and the members of the other union involve themselves in a strike and support or express their sympathy with the members of union who are on strike in other undertaking. The workers of a sugar industry may go on strike in sympathy with their fellow workers of the textiles industry who may already be on strike as well. We'll talk about the third one, which is your general strike. In general strike here, it means a strike by members of all of the most of the union that in a region or an industry. It may be strike of all the workers in a particular region of industry to force demands common to all workers, and these strikes are usually intended to create a political pressures on ruling government rather than or any one employer. It may also be the extensions of the sympathetic strike to express generalized protest of the worker as well. Talk about the fourth one, which is your the sit down strike. And sit down strike, in this case, that the workers do not absent themselves from their place of work when they are on strike. They keep control over production facility but do not work. Such a strike is also known as a pen down or a tool down strike. Workers shows up to their places of employment and but they refuse to work. They also refuse to leave, and which make it very difficult for the employer to defy the union and take the workers' place. An example, in June 1998, all the municipal corporation employees in Punjab observed a pen-down strike to protest that against the non-acceptance of the demands of the state government. That has been done in India in Punjab 1998, the pen-down strike. The fifth we'll talk about it, which is the another one, which is slow down strike. Slow down strike. In slow down strike, that the employees remain on their job under this type of a strike. They do not stop work but restrict the rate of output in an organized manner, and they adopt go slow tactics to put pressures on the employers. The sixth is your hunger strike. Under the hunger strike here, that in the form of the industrial protest, the workmen resort to fasting near the workplace in order to demand the employers to reduce their grievances as well. Example on this, that is on 18th July 2012, India's leading car manufacturer Maruti Suzuki Udyog that limited is in Manis, that is your Manesar factory, that they had take the hunger strike here. Now we'll talk about the seventh one, which is your Wildcat Strike. In Wildcat Strike here, that is your these strikes are conducted by the workers or the employee without the authority and the consent of union. Example, like in 2004, a significant numbers of advocates went on a Wildcat Strike at the city civil court premises in Bangalore. They were protesting against some remarks allegedly made that against them by the assistant commissioner here. So these there were the seven strikes that we had talked about it, as I told you, which is economic strike, sympathetic strike, general strike, sit down strike, slow down strike, hunger strike, and wildcat strike as well. Now we'll discuss about the other question that we have is your what do you mean by strike and lockout? What is the difference between the two? So we'll have to discuss about the strike and the lockout, and then we have to discuss the differences between two, which has been asked in 3 times examination paper of 5 marks. We'll talk about the strike, we know about it, and we'll discuss the difference between the strike and lockout. So difference between that is strike and lockout. The difference between strike and lockout, that we'll talk about it. Strike is a weapon in the hands of the laborers to force the management to accept their demands, and similarly the lockout is a weapon in the hands of the management to coerce the laborers to come down in their demands relating to the conditions of employment. Lockout is the keeping of labor away from works by an employer with a view to resist their claims as well. In the same cases, we will go ahead here, and that we will have to talk about it, which is the different point to distinction between the strikes and lockout. So in who stops the work here? In strike, employees, and lockout, in employer. What is the action? In strike, that refusal to work or working of decreased pays as well, and in lockout, refusal to allow employees to work. When the tactic used, and that is in strike, that is a deadlocked labor negotiation, and in lockout, that is deadlocked labor negotiation. And then what's the pressure? The strike, in strike, that is the decreased productions and therefore the decreased earning for the other side, and for the lockout, that the economic hardship and imposed on workers, that is the decreased earning for the other side. And why strike? That is your as that bargaining tool in influencing the employer's concessions in contrast term, and in lockout as the bargaining tool that to pressure employer and accepting the concession to the contrast terms as well. In employees that entitled to the unemployment benefits for the strike here, if the strike is caused by the employer's willful failure to observe the health and the safety sections of the union contract, and that is for the lockout, that is your employer not entitled as well. Now we'll go ahead with further one, that what we have to talk about it, and which is the other question, what is code of discipline, and that has been asked of 6 marks. What is code of discipline? Explain in detail of 6 marks. Explain principles of industrial disciplines, that has been also asked of 6 marks here. So we'll discuss about it, which is code of disciplines in industry. Codes of discipline So codes of disciplines and industry, that we talk about it here. In the same cases here, that to maintain the harmonious relation and the promote industrial peace, a code of discipline has laid down, which applies to both public and a private sector enterprises, and that it specifies the various obligations for the management and the workers, with the objections of promoting the cooperation between their representatives as well. In the same cases, that is the principles of code, if I'm talking about the principles here, that is your the principles of code of disciplines here. In this, the code is based on the following principles, and that we talk about it, which is there should be no strike or lockout that without prior notice, and no unilateral actions should be taken in connection with any industrial matter. Employees should follow go slow tactics, and no deliberate damage should be caused to a plant or property, and act of violations, that intimidations and the questions that should not be resorted, and the existing machinery for the settlement of disputes should be utilized, as well as the action that disturbed the cordial relationships that should be avoided as well. In the same cases, we'll talk about the importance of code of discipline, and importance of codes of discipline, that we go ahead, and that is the importance of code of disciplines here. Importance of code of discipline in industry. So importance of code of disciplines in industry, we talk about it, which is the code of disciplines has been helpful in improving industrial relation in the country. The code of discipline is a major steps in establishing the orderly atmosphere in the industrial unit. To maintain the discipline in industry, the main objective of code are: the first is to maintaining the peace and order in industry. Second is to recognize the right and responsibilities of each other. The third is it prohibits the strikes and lockouts. The fourth is facilitating a free growth of the trade union. The fifth is the settlements of disputes. And the sixth is that the union will discourage of duty damage to property and careless operations in subordinations and other unfair labor practices on the part of the workers. And the seventh is that avoiding the work stoppage in industry as well. We'll talk about the another one, which is your the obligation that to be observed code of discipline. That is obligation to be observed under code of disciplines. So the obligations that to be observed under the code of disciplines here. In this, if I'm talking about that is your the code of discipline consists of the three sets of principle. The first is the management and union agree. The second is the obligation that to be observed by the management, and the third is that the obligation to be observed by the trade union. and now we'll discuss one by one here itself, and that it will go ahead as well. So in the first we talk about it, that is management and unions agree here. Management and unions agree in this, that is that no unilateral action should be taken in connection with any industrial matter, and that dispute should be settled appropriate level, that the existing machinery for the settlements of disputes should be utilized with the utmost expediencies, and that is your DNC and expediency, and that there should be no strike or lockout without notice, they affirming their faith in democratic principles, and they bind themselves to settle all future differences, disputes, and grievances by the mutual negotiations, conciliations, and voluntary arbitration. That neither party will have resources to that is your coercions, intimidations, victimizations, and go slow, that they will avoid, that is litigation, sit down and stay in strike and lockout, that they will promote the constructive cooperative between their representative at the level and between workers themselves, and abide to spirit of agreements mutually entered into, and that they are established upon a mutually agreed basis and a grievances procedure which will ensure a speedy and a full investigation leading to settlement as well, that they are be able, that they will abide by various stages in the grievances procedures and take no arbitrary actions which would bypass these procedures, and that is that the last, the tenth we have is your, that they are, will educate the management personnel and working that regarding their obligations to each other as well. The second we have is your management's agree. And managements agree not to increase the workloads unless that agreed upon as settled otherwise, not to support or encourage any unfair labor practice such as interferences with the right of employee, and to enroll or continue as union members, and discrimination, restricts or coercion against any employee because of recognized activity of the trade union, and victimizations of any employee and about authority in any form as well, to take promote actions of that is your settlements of grievances, implementations of settlements, awards, decisions, and orders, and to display in the that conspicuous places in the undertakings, that the provisions of the code, that in the local here, that is local language as well, and to distinguish between the actions justifying the immediate discourage and those where the discourage that might be preceded by the warning, and reprimand the suspensions or some other form of disciplinary actions, and to arrange that all such disciplinary action that's to be subject to an appeal through normal grievances procedure, and to take the appropriate disciplinary actions against its officers and members in case where the inquiry reveals that they were responsible for the that your precipitate action by the workers leading in disciplines, and to recognize the union in accordance with the criteria given hereafter, and evolved at the 16th sessions of the Indian Labour Conference held in May 1958. We'll talk about the third one, which is your unions agree. And unions agree, if I'm talking about here, that to not to engage in any form of a physical duties, and that is in the same case not to permit the demonstration which are not peaceful, and not to permit that is your rightisms and the demonstration, that they are the member will engage or cause other employees to engage in any union activity during the working hour unless as provided by a law, agreement, and practices, to distinguish unfair labor practices such as negligences of duty, careless operation, damage in property, interferences with distributions to the normal work, and the insubordinations as well. In the same cases here, We'll talk about it, and that is your the other one, and that is that to take the prompt action to implement the awards, agreements, settlements, and decisions as well, to display in the conscriptions places in the union offices and provisions of the code in the local language, and to express the disapproval and to take appropriate action against the office bearers and the members for indulging in actions against the spirit of the code as well. We will talk about the other question, which is your describe in a brief the provisions of Industrial Employment Standing Orders Act 1946 that has been asked of 6 marks, and where the other question is being that write a short note on Standing Order Industrial Employment Act 1946 that has also been asked of 5 marks, and the other question in terms of it, what is meant by the model standing orders, and are these orders applicable to all establishment, what is the scope of their application, that has been asked of 10 marks, and discuss the major provisions under the Industrial Employment, which is Standing Order Act, that has been asked of your 6 marks. So we'll go ahead with it. That will discuss standing order, which is introduction and definition. Standing order, which is introduction and definition. So standing order, introductions and definition, that we talk about it in this, that is to avoid the friction among the employers and workmen employed in an industry is a principal aim to the Indian legislations in India, and that is it was considered that the society had a vital interest in the settlements of terms of employment and that of industrial labor, and also settlements of the labor problems. Therefore the steps were taken to the central government to enact Industrial Employment, that is Standing Orders Act 1946, with a view to afford the protections to the workmen with regard to the conditions of employment. The definitions under the Act, Section 2, that standing order means rules relating to the matters set out to the scheduled to the Act, Section 2G, that to be that covered, and in respect to which that the employers had to draft for submissions to the certifying the officers or matter that's specified in the schedule as well. We'll talk about the objectives of the Act here. In the same cases, the objectives of the Act. In the objectives of the Act here, that the purpose of having standing orders at the plant level and the other commercial establishment is to regulate industrial relation, and this order regulate the conditions of employment, grievances, misconduct, etc. of the workers employed in the industry undertaking, and that is unsolved grievances that can become the industrial disputes as well. We are in the same cases, we go ahead with this, that is the another one, which is model standing orders, and model standing orders includes the following contents. So we'll go ahead, and that is your models standing orders. In model standing orders that conclude here, which is the classification of workers, publications of work time, holidays, pay days, and wage rates as well, shift working, attendance and late coming, as well as leave and holidays, casual leave, payment of wages, stoppage of work, as well as the terminations of employment, disciplinary actions in a misconduct, suspension, dismissible, and that is your complaint as well. In the same case, we'll talk about the procedures for the approval of standing orders here. So in the procedures here that we talk about it, which is your procedure for the approval of standing orders. In this, that the main provision that deals of the approval of standing orders, with the procedure for the submissions of draft standing order section 3, and procedures for the conditions for certification of standing orders section 4, procedure for the certification of standing orders, procedures for adoption, that is section 5, and appeals is your section 6. We'll talk about the procedure for the submission or to draft standing order, which we have is within 6 months from the date of on which this act becoming applicable to the industrial establishment, and the employer that should submit to the certifying officers 5 copies through the draft standing order proposed by him. Provision shall be made that as much as every asset out of this that schedule which may be applicable to industrial establishment and that were modeled standing orders have been prescribed, subject to such conditions as may be prescribed as a group of employers in similar industrial establishment that may submit a joint draft or standing orders under this section as well. The other procedures, we have the procedures for that is the certification of standing orders procedures for the adoptions, we can say that. And for that I will go ahead with one by one all procedure. That is your procedures for the submission of draft standing orders. The next is your procedure for certification of standing orders, that is procedure for adoptions here as well. In this, that the certifying the officer receipt of the draft standing orders from the employer that should forward a copy to a draft standing orders, and that to recognize the trade union to establish seeking the submissions of objectives to draft standing orders, if any. The standing orders that came into the operations on the expiry of 30 days from the date on which that the authenticated copies of the standing orders are forwarded to the employers and the workmen by the certifying officers, and the conditions of the employment which will be binding up the employer and the workmen from the date when that became operational as well. We'll talk about the other one, which is appeal of standing orders here. In appeal of standing orders here, in the same cases that we'll talk about it. In this, that is your any employer that workmen, trade unit or the other prescribed representatives of the workmen aggrieved by the order of certifying the officers that may appeal to the that is your appellate the authority within the 30 days from the date of which the copies are to be sent to them, and the appellate authority that may confirm the standing orders by the certifying or may takes modifications or additions to render them the certifiable, and it has been sent copies to the same concerned person within the 7 days of the order, section 7 here. We'll talk about the other one which we have here is that is your modification of standing order as well. Modification of standing orders. So in modification of standing orders here, that standing order finally certified under the act that shall not accept on agreement between the employers and the workmen on their trade union that be liable to modification until the expiry of the 6 months from the date of which the standing orders came into operations, and the subject to the provisions of subsections that the employer of the workmen or a trade that a union that we have, and that is the trade union or the other representative body of the workmen that may be apply of certifying the officers to have a standing orders modified, and such application shall be accompanied by the 5 copies of modification proposed to be made as well. So next we have to talk about definitions of certifying officers, powers of certifying officers, payment and subsistence allowances, offences and penalties, that we'll discuss in the next coming class. So we'll end up here itself, and we'll completed your unit 4 here however, and only the one topic has been there for it. So we'll discuss in that in the next coming class, and it's a huge request from my side to all the viewers, please go through with the subscribe button and please like, share and subscribe our channel so that many and maximum people can get the information at once, and even you can also enjoy the video as well, and you will be getting all the videos here which we had completed the unit 1, unit 2, unit 3, unit 4 and unit 5 we will complete shortly, and we'll end up with unit 4 as well in this next coming class, and the first topic that we had taken out here as well. So you can go through with that, and other than that we'll start discussing about related to this. So thank you, hope you enjoy this video. If you like this video, please give a thumbs up and give a suggestion in the comment box.